The room held about 300 people, and my father managed to silence every single one of them. It was a Tuesday evening in late March, the kind of gray sky Ottawa day that hadn't quite decided whether to snow again or just threatened to. The Department of Justice Awards reception was being held in a glass and limestone hall overlooking the Ottawa River, the kind of venue where you were expected to feel the weight of what the country stood for. Flags, portraits, Parliament Hill lit up through the floor-to-ceiling windows like a postcard nobody had asked for. I was seated in the 7th row. My blazer was second-hand, bought from a consignment shop on Bank Street, and I was holding a glass of sparkling water because my hands needed something to do. I was 31 years old. I was a staff lawyer at the Reconciliation and Environmental Rights Clinic, a small, underfunded organization operating out of a walk-up office near the University of Ottawa campus. For 4 years, I had been doing work that nobody in that room had heard of, and nobody outside of it seemed to care about. My father was seated in the VIP section. I could see him from across the room, and that was always the problem with being his daughter. You always could. He had the posture of a man who had decided long ago that rooms existed for him to fill them. He was a developer. He built things. Commercial towers in Mississauga, subdivisions outside Barrie, a waterfront condo project in Kingston that was still in litigation. His name was on buildings, actual buildings, with plaques. Beside him sat my brother, 29, already a junior partner in my father's company, already carrying himself the same way. That particular brand of confidence that comes not from having earned something, but from never having been told you hadn't. I hadn't spoken to either of them in 8 months. The deputy minister at the podium was making her way through the evening's second award. I focused on the program in my hands, on the small black text, on keeping my breathing steady. I had been told, weeks earlier, through a formal email from the Office of Justice Ouellette of the Federal Court, that I would be recognized this evening for my work in Indigenous environmental law consultation, specifically for a case that had, against every expectation, reached the Federal Court of Appeal and changed the way duty to consult assessments were conducted across this country. I had not told my father I would be here. I had not been planning to. I didn't know they would be here either. The deputy minister's voice shifted. She was reading my name now, and the words she used to describe my work, groundbreaking, precedent-setting, a model for Indigenous Crown consultation that other jurisdictions are now actively studying, landed in the room like stones dropped into still water. I heard them the way you hear your own name called in a dream, distorted, unbelievable. And then my father stood up. Not to applaud. He stood the way he always had, with the full conviction of a man who had never once questioned whether the floor was his to take. He stepped into the aisle. He raised one hand. The deputy minister stopped speaking. I have been in rooms where silence happens by accident. This was not that kind of silence. This was the kind that gets pulled out of the air all at once, like a tablecloth yanked from a set table. My father's voice carried, it always had. I have to say something. He looked around the room as though addressing a board meeting. This is well-intentioned, but I have to be honest. Environmental advocacy isn't law. It's sentiment with a barcode. The real work of this country is being done by people who build things, who create employment, who generate the tax base that funds all of this. He gestured broadly at the room, at the flags, at everything. My daughter means well, but what she does isn't what keeps this country running. 300 people turned to look at me. I had felt shame before, real shame, the kind that lives in the body, that makes your jaw tighten and your chest cave inward. I had felt it at age 22, at a kitchen table in Oakville, holding a letter I'd waited 3 months for. I knew exactly what shame felt like, but this was something different. This was being dissected in front of your entire professional world by the person who was supposed to be your safe harbor, while your brother stood one step behind him with an expression that said he'd been waiting for this moment for years. I don't know how long the silence lasted, seconds maybe. It felt like a tide going out. And then Justice Ouellette stood up. He was a quiet man, Bernard Ouellette. I had appeared before him twice in my career, once as a junior counsel barely keeping her voice steady, and once as the lead on the duty to consult case that had changed things. He was small and unhurried, with the kind of authority that doesn't need volume to make itself known. He stepped toward the stage. He looked briefly at my father, and then he looked directly at me, across the entire length of the room. Please come forward, he said. This recognition exists precisely because of the work your father just described. He said it quietly. He didn't raise his voice. He didn't argue. He stated a fact and then waited for the room to catch up to it. And the room did. It started with a woman in the 3rd row, a senior legal counsel I had met once at a conference in Gatineau, who had told me privately that our case had changed how her office handled Crown consultation. She stood up, then the man beside her. Then, in a slow and unhurried wave that moved from the front of the room backward, 300 people rose to their feet. My legs moved before I gave them permission. I walked down the aisle. I walked past my brother, who had stopped looking triumphant and started looking like a man watching a building fall that he had been certain was standing. I walked past my father. He was still standing in the aisle. His face, which had been flushed and certain 30 seconds ago, had gone the color of old snow. He looked at me, and for the first time in my life, I did not see the particular disappointment that had been his default expression for me since I was old enough to have opinions. I saw something rarer. I saw shock, not the performative kind, the genuine article. I kept walking. I thought, as I reached the stage, about a kitchen table in Oakville, about a December night 9 years ago, about a letter that nobody had bothered to open. It was 2 days before Christmas. My mother had been gone for 4 years by then, and what remained of the holiday in our house was a set of traditions we performed without her, carefully and a little desperately, the way you maintain a fire that's struggling to stay lit. My brother was home from Queen's Commerce, trailing behind him the easy confidence of someone who had already decided he was exceptional. I was 22 and in my final year at McMaster, and I had been carrying a secret in my coat pocket for 3 weeks. The acceptance letter from Osgood Hall Law School had arrived on a Tuesday, full scholarship, environmental and Indigenous law stream. I had read it 4 times in the parking lot of the grocery store where I worked part-time, and then I had sat in my car for 11 minutes doing something embarrassing that I won't describe here, except to say it involved laughing and crying at the same time, and then calling my best friend from high school, who screamed so loudly I had to hold the phone away from my ear. I waited for the right moment to tell my family. There is no right moment in a house like mine, but I told myself there was, and I kept waiting. It was Christmas Eve dinner. My aunt had made her trifle. My uncle was talking about the Leafs. My father sat at the head of the table, pouring wine and conducting the gathering the way he always did, as though the evening were a project he was managing to completion. My brother had just finished telling a story about a case study competition he'd won at school, and my father had listened with the particular focused attention he reserved for things he found genuinely impressive. I pulled the letter from my cardigan pocket. My hands were steadier than I expected. "Dad," I said, "I got in somewhere I wanted to tell you tonight." He took the letter. He looked at it the way you look at something you're not planning to read, skimming the letterhead, catching the shape of it without taking in the words. Then he set it down on the table, not in front of him, not in his own space. He set it near the platter of roasted vegetables my aunt had made, next to a serving spoon, in the space reserved for things that needed to be moved out of the way. He didn't open the envelope. "Environmental law," he said, not a question. "Indigenous rights," I added. "It's one of the strongest programs in the country. The scholarship covers everything: tuition, living expenses. Look at your brother." He didn't raise his voice. He pointed with his fork toward my brother, who was leaning back in his chair with an expression of practiced neutrality that I recognized as the face he wore when he'd won something. "He's going to come back this summer and start learning the business. That is a future. That is something you can build on." He reached for his wine glass. "What are you going to do with Indigenous land claims? Who does that help?" My aunt looked at her trifle. My uncle looked at the TV in the next room. My brother shrugged in a way that communicated indifference and satisfaction simultaneously, a gesture he had perfected so thoroughly it barely looked deliberate anymore. My father raised his glass. "To your brother," he said. "To the next generation of the company. We're proud of you, son." Glasses clinked. My aunt smiled warmly. My uncle nodded. My brother accepted the toast with the grace of someone who had never doubted it was coming. My letter sat beside the serving spoon. I didn't cry at dinner. I waited until I was in my childhood bedroom with the door closed, and then I cried the way you cry when you finally understand that the game has different rules for you, and always did, and you've only just worked up the nerve to admit it. I thought about my mother. She had loved trees the way some people love music, not as scenery, but as something alive that deserved attention. She had taken me to Algonquin Park every September when I was small, and she had taught me the names of things, not just the English names, but the Anishinaabe names she'd learned from a colleague at the public library where she worked. She used to say, "Knowing the name of something is the beginning of caring for it." She had died of ovarian cancer when I was 18, and she had left me, among other things, a battered copy of Thomas King's The Truth About Stories that she had marked up in pencil, with notes in the margins. I was still, years later, working my way through. I went to Osgood. I did not go home the following Easter. The years after law school were quieter than I'd expected and harder in the ways I hadn't prepared for. I articled at a mid-sized firm in Toronto that occasionally took environmental cases, and I was good at it, and nobody particularly cared. I was the associate who read the land use reports nobody else wanted to read, who attended the consultation meetings with First Nations community representatives that my supervising partner kept canceling on short notice, who wrote the memos that ended up in filing cabinets. I was competent and largely invisible, which is a particular kind of professional loneliness that's difficult to explain to people who haven't lived it. I left for Ottawa after 2 years. I took a position at the Reconciliation and Environmental Rights Clinic, a nonprofit that operated on grant funding and a very specific kind of stubbornness, and I was immediately and thoroughly broke. I lived in a one-bedroom apartment in Centretown with a radiator that sounded like an argument and a window that looked directly into another building's hallway. I wore the same blazer to every hearing. I ate a lot of lentil soup, but I was doing the work I had gone to law school to do. It was in that first year at the clinic that I met Reid. He was a researcher at the University of Ottawa's Faculty of Law, working on constitutional frameworks for Indigenous rights, and he had come to one of our small roundtables looking for practical grounding for his academic work. He arrived 15 minutes early, which was unusual, and he sat in the back row, which was rarer. After the session, when everyone else had filed out, he stayed. "The methodology you described," he said, "the cultural context mapping alongside the environmental science. I've never seen it applied this way in consultation work before. Where did you develop that?" Nobody had asked me that before. Not like that. Not with genuine curiosity about the process rather than just the outcome. We talked for 2 hours. He came back the following week and the week after that. He brought academic papers, I brought case files, and together we built something that neither of us could have built alone. A framework for conducting due-to-counsel assessments that centered Indigenous knowledge protocols alongside regulatory requirements, that didn't treat oral testimony as secondary to written reports, that took seriously the idea that relationships to land exist in time, in ways that a standard environmental assessment simply wasn't designed to capture. It was slow work, unglamorous work, the kind that doesn't photograph well and doesn't fit in a press release. But it was real, and after 3 years of it, it found its way into a federal court case that nobody believed we could win. My father called 6 weeks before the final hearing. I recognized his number. I almost didn't answer. Piper. His voice was the same as always, unhurried, certain of its own authority. "Your brother and I have been following the Macoonsag case. We need to talk." The Macoonsag case involved a proposed mining access road in northern Ontario that would cut through territory with unresolved land claims and directly affect a critical watershed. The company pushing the project had completed a federal environmental assessment, but the duty to consult process had been, in my opinion, and in the opinion of the 3 First Nations communities we represented, a procedural exercise with no meaningful engagement behind it. We were challenging it in federal court. "I'm listening," I said. "The assessment report is what's holding things up," my father said. "The project has real employment potential for the region. What the report needs is someone who understands both the regulatory side and the community concerns, someone who can make the language less adversarial, soften some of the findings." He paused. "There are interests connected to this project, Piper, family interests." My brother's voice joined from what I assumed was a speakerphone. He sounded smooth and reasonable in the way that he'd always been able to manage when he wanted something. "Come on. This is how things actually get done in this country. You'd be helping the community too. Jobs, infrastructure, investment. Don't be rigid about this." I listened to my own breathing for a moment. I thought about the watershed. I thought about the elders I had sat with the previous spring in a community hall north of Timmins, who had described that river system to me for 6 hours, showing me hand-drawn maps their grandparents had made, who had been attending government consultation sessions for 9 years without receiving a single substantive response. I thought about my mother's pencil notes in the margins of a book about the truth of stories. "No," I said, "I won't do that." "Piper." "No." I ended the call. 3 weeks later, someone broke into the clinic's office on a Wednesday night. The physical damage was minor. A back window, a filing cabinet. What was missing was a set of physical consultation records from the Northern Ontario case and a portable hard drive containing recorded testimony from community witnesses. Testimony that had taken us 2 years to gather. Testimony that was the backbone of everything we had built. I reported the break-in to Ottawa police. I filed with the federal court. I was told, through an intermediary in the Attorney General's office, that the loss of the records was concerning and that my case had been significantly weakened. The tone made it clear this was being communicated as my failure to manage my files properly. I called Reed at 11 o'clock that night. He came to my apartment with his laptop and a thermos of coffee, and we worked until nearly 4 in the morning. He pulled the metadata from files the intruder had failed to fully delete from the clinic's cloud backup, files that had been accessed remotely before the break-in, then corrupted. The access signature traced through a private server to a company registered in Ontario. The company was a subsidiary of my father's development group. We found the emails an hour later. My brother had coordinated with a data consultant through messages he had apparently believed were permanently private. One of them read, "Make sure the interview recordings are unrecoverable. The case doesn't hold without them." I sat in my kitchen in the gray, early morning and looked at what was on the screen and felt something cold and clarifying move through me. Not surprise. The thing that surprised me most was how completely unsurprised I was. I had one call left to make. I made it to Justice Wellett's clerk the next morning and submitted everything in a sealed package. The metadata analysis, the email chain, the corporate registration connecting the subsidiary to my father's group. My cover letter said only, "The integrity of this proceeding and the rights of the communities depending on it are at risk. I am asking that this evidence be entered into the record before the final hearing." 3 weeks later, a formal invitation arrived. A Department of Justice Awards reception in Ottawa. My attendance was requested. I understood immediately what it was. The stage was smaller than it looked from the 7th row. Justice Ouellette shook my hand and held it for a moment, longer than a handshake requires, which I understood as a communication of something that formal proceedings didn't allow him to say directly. Behind us, on the large display screen facing the audience, the deputy minister had opened a file. She explained, in the careful measured language of someone who had prepared this with great precision, what the documents showed. The corporate trail, the digital access log, the email thread, what had been at stake, and what it would have meant for the Macoonsag watershed communities if the evidence had been successfully destroyed. The screen changed to show a name. My brother's name. The room didn't erupt. It went very still, the way rooms go still when something real is happening and no one wants to make a sound that might interrupt it. Then 2 investigators from the RCMP's commercial crime section, who had been seated quietly near the back of the hall for the entire evening, walked toward my brother with the unhurried efficiency of people who have done this many times and would rather not make a scene. My brother stood. He raised his hands. He tried to say something. I could see his mouth moving, could see the shape of a denial forming, and then the investigators were beside him, and then it was over. My father did not stand up. He sat at his table in the VIP section and looked at the screen, and then looked at me on the stage, and looked like a building after the foundation has been pulled out, still standing, technically, but wrong in a way that couldn't hold. The confidence was gone. In its place was something I had never once seen on his face in 31 years. He looked afraid. I did not feel what I had imagined I would feel. I had thought about this moment for 8 months, and I had expected satisfaction, or relief, or the particular sweetness of a long argument finally resolved. What I actually felt was tired, not the kind of tired that sleep fixes, the kind that lives in the deeper places. Justice Ouellette leaned toward me and said, quietly enough that the room couldn't hear, "You did good work, Ms. Holbrook. It mattered." "Thank you, sir," I said. I walked off the stage. My father asked to meet me a week later. I agreed, because I needed to close a door, and the only way to close a door is to walk up to it. We met at a small cafe near the Rideau Canal. It was early April, and the ice was going out of the canal, that slow gray-brown unlocking that happens every spring, that always looks reluctant and then suddenly looks inevitable. He was already there when I arrived. He looked older than I remembered. The authority had gone out of him the way heat leaves a room when the furnace stops, quietly and then all at once. There was a small leather case on the table beside his coffee. "Your grandmother's pearls," he said. "I've been holding on to them. I thought you might want them now." He looked up, and his eyes were asking something his words weren't quite saying. "Let's find a way forward, Piper. We're still family." I looked at the leather case. I looked at him. He said, "What happened? That was your brother's decision. I didn't know the extent of." "You knew enough," I said. He looked at his coffee. He didn't argue, which told me more than any argument could have. I thought about a letter lying beside a serving spoon on a Christmas Eve table. I thought about a toast with my name left out of it. I thought about a voice on a speakerphone saying, "Make sure the files are unrecoverable." I thought about pulling over on the 417 after the hearing decision came down, sitting in my car in the January cold, crying in a way I hadn't since my mother died, not from sadness, but from the sheer weight of having carried something that heavy for that long, and finally being able to set it down. I pushed the leather case gently back across the table. "I don't need those," I said. "I hope you're okay. I genuinely mean that." I stood. My chair made a soft sound on the floor. "But I can't be the proof that this family turned out all right. I have my own life to build." He didn't say anything as I left. I didn't look back to see his face. Outside, the canal ran gray-brown with meltwater, and the trees along the bank were beginning, tentatively, to think about leaves. That autumn, I started teaching a seminar at Carleton. Just a seminar, 8 students, called Environmental Law and Indigenous Consultation. Frameworks for Meaningful Engagement. It was offered as a law faculty elective and had nearly not been approved at all, on account of low projected enrollment. I taught it anyway. On the last day of the term, after the other students had gathered their coats and filed out into the November afternoon, one student stayed behind. She was 24, Cree, from a community in northern Ontario, the first in her family to attend university. She had spent the entire seminar asking sharper questions than anyone else in the room, the kind of questions that came from someone who already knew the problem intimately and was searching hard for the language of solutions. "I didn't know this was a field," she said. "I knew the problems existed, but I didn't know there was a legal framework that could actually address them. I didn't know someone was out there doing this work." I didn't know what to say to that for a moment. Then I said, "Someone has to." She nodded slowly. "I'm applying to law school next fall." "Good," I said. She left. I sat alone for a while in the small seminar room, which was cold and smelled like dry erase marker and old carpet, and I thought about a battered Thomas King paperback with pencil notes in the margins. I thought about September trips to Algonquin Park when I was 7 and 8 and 9, and the names of things, and the idea that knowing the name of something is the beginning of caring for it. I had spent so many years trying to earn something from people who were never going to give it. I had spent so many years measuring myself against their distance from me. And somewhere along the way, through the underfunded clinics and the late-night sessions, with a thermos of coffee and a federal court file that took 4 years and one impossible night to build, I had stopped needing it from them. I hadn't noticed when it happened, which is, I think, how healing tends to work. Not like a switch. More like the ice leaving the canal in April. Slow, and then suddenly, all at once, you realize the water is moving again. My phone buzzed. A message from Reed with a link to a new paper out of UBC on duty to consult reform, citing our framework 7 times. I read the message twice. Then I turned off the seminar room light, pulled on my coat, and walked out into the November dark, which in Ottawa is cold and honest and beautiful in its own unsparing way, the stars very bright above the bare trees, the city going on around me in all its ordinary necessary noise. I wasn't invisible anymore. I was exactly who I had always been, and that I was finally beginning to understand, not just know, but actually understand, in the place where understanding settles and stays, was more than enough.